justice for all.
Got some announcements. The First District Court of Appeals graciously lets us use their facilities, so please be respectful and respect their rules, and have absolutely no food or beverages other than water in this room. Please also silence your cell phone. Anyone addressing the commission, please speak up so our recording equipment can pick up you properly. My fellow commissioners, please speak up and into the microphone so you can be heard. Members, I also ask that you be brief and concise as possible with your questions and comments, as we have a number of items for consideration today. Pursuant to section 286.014 Florida statutes, members of the public have an opportunity to have input on matters before the commission, other than in cases which we act in a quasi-judicial capacity. This means the public can have input on matters other than complaints, opinions, and determinations in financial disclosure cases. If you desire to be heard, please fill out a speaker form and give it to Ms. Fulward, who has her hand up. All right, now we move on to the next item on the agenda, which is the approval of the minutes.
I move they be approved as circulated. That's,
See that it's been properly moved and second. Any discussions? All right, all in favor, say aye.
aye.
See that it's been properly moved. All right, we move on to item 4. We have before us a proposed settlement in complaint number 22-039 in re Justin David Phillip. Will the parties or their counsel please identify themselves for the record? Okay. Probable cause was previously found in this complaint, and now we have before us a proposed joint stipulation between the commission advocate and the respondent. After considering all the materials and the presentations of the parties, the commission may vote to approve or reject the stipulation. If you reject the stipulation today, the complaint will go to the Division of Administrative Hearings for an evidentiary hearing on, or the parties can negotiate a new settlement for consideration at another commission meeting. The parties cannot renegotiate and present a new stipulation at this meeting, nor can the commission negotiate a new stipulation. Complainants have the right to respond in writing to proposed stipulations. We have not received any comment from the complainant in this case. Ms. Hadley, you are now recognized to present the stipulation.
In this case, respondent is a former program specialist for the Florida Department of Education who violated Article 2, Section 8G2 Florida Constitution by using his position to obtain a disproportionate benefit for himself, and Section 112.3136 by using his position to secure a privilege, benefit, and/or exemption for himself or another. Through settlement discussions, the parties have come to an agreement. Please note, respondent has reimbursed the proper entity regarding the advance payment request and gift cards. In the stipulation, respondent admits he violated the Code of Ethics and agrees to the entry of a final order recommending a total civil penalty of $2,000 with public censure and reprimand. We respectfully ask for the commission's approval of the joint stipulation.
All right. Questions from the members? Seeing no questions?
Move approval. Second.
Okay, any discussion? Seeing no discussion? All in favor of the recommendation? Say aye.
Aye.
All opposed? See that it's properly moved and second. All right, moving on to item 5, consideration of the advocate's motion to adopt advocate's recommendation. Oh, this matter is the consideration of the advocate's motion to adopt the advocate's recommendation. Order finding probable cause. Recommend a penalty and issue final order in complaints numbers 19-100 through 19-120 consolidated. Marie Melanie Gerardo. This matter is before us in a final hearing because it appears that there are no disputed facts. Is Ms. Gerardo present?
No, she is not.
Okay. All right. This hearing will be conducted in pursuant to sections 120.569 and also 120.57-2 Florida statutes and Rule Chapter 28-106 Florida Administrative Code. At this hearing, we will resolve any disputes issued of law, and if any violation is found based on the facts to determine what the penalty is appropriate. Both parties will have the opportunity to present to the commission any oral or written evidence related to the complaint. If the dispute of the material facts is asserted during this hearing, we will refer to the complainant back to DOA for a hearing. Each party will be given 15 minutes to present his or her argument, starting with the advocate. Commission members, you may raise question at any time during this proceeding. Only testimony and evidence relevant to this complaint will be allowed. Members, you have a memo and a final draft order from the staff, as well as the advocate's motion included with all of the relevant documents in this matter. Ms. Miller, you are recognized to present your motion.
Thank you. Good morning, Commissioners. Elizabeth Miller, advocate for the Commission. You may recall this case. The respondent was the mayor of Temple Terrace. She bought a PhD degree from a diploma mill and directed the City of Temple Terrace staff to post that she was a doctor on the city's website. Due to the community uproar, she resigned from her position. There's one allegation, and that's misuse of office. The morning of the DOA hearing, she entered into a stipulation whereby she agreed to pay a $5,000 civil penalty and accept a public censure and reprimand. I brought the stipulation back to the commission where it was rejected. I then sent the case back to DOA. Respondent and or her attorney failed to participate, chose not to participate, and the administrative law judge deemed all the facts admitted. Therefore, there are no necessary facts to prove, no further facts to prove a violation. They have all been admitted by the respondent's failure to participate. The commission now has before it my recommendation of a $10,000 civil penalty along with a public censure and reprimand, and I respectfully ask you to adopt that. Thank you.
Okay. Members, I apologize. I should have asked if there was any disclosures. Prior to this coming before us, I mentioned that I disclosed that I knew I was acquainted with the respondent, and if there's any other members who want to disclose, they can as well. Okay, hearing none. All right, is there any questions, members? Sir.
Thank you, Mr. Chair. Just as procedural, because I believe the law's changed, and I don't know, and now our maximum fine that we can do is $20,000. Is that been implemented already, or?
Through the chair, it was not at the time that this offense occurred, and when we went to DOA, it was still $10,000.
But if it were, would we be able to, at this stage, be able to increase it, or is that, this is your recommendation, so we could, if we wanted, I know we can't do it in this case, I'm just asking for future matters, would we be able to, at this stage, increase it even though you're coming to us with this recommendation?
Yes, ma'am.
Through the chair, I would have asked for $20,000 if that were the case, but if I hadn't, I do believe you can change it. You can increase it if that's your wish.
Okay. Sir.
Thank you, Mr. Chair. Just a quick question. When you say that she failed to participate, could you elaborate?
I beg your pardon?
You said that the respondent failed to participate. Could you elaborate at all in the process, or could you elaborate on that, please?
I'll be happy to. Again, through the chair. For the first DOA hearing, she had an attorney. He did resign representation after the commission rejected the stipulation, so she was pro se. I contacted her many times, which all my contacts are documented by phone and by email and by U.S. mail. She never, ever responded to me. I also tried to get to her through her attorney, and he never would respond back to me either. I asked the judge to admit all the admissions. I had asked her through discovery to admit all the elements to prove a violation. She did not participate. I therefore went back to DOA and asked the judge to grant all the admissions. Because she didn't participate, she must believe there are no disputed facts. The judge did grant all the admissions to prove a violation. Prior to doing that, he sent an order to not only her attorney, but to the respondent herself, It was an order to show cause why she was not participating. And then there was a telephonic hearing on that. She did not respond. There was absolutely no communication between the judge, myself, and the previous attorney or Mrs. Gerardo.
Thank you.
You're welcome.
Any other questions?
Mr. Chairman, I move the advocate's recommendation.
Okay, so, oh, well, I do see a question. Yes, sir.
Well, I was going to respond to the motion. I guess it hadn't been seconded yet.
Oh, okay, got it. See that it's properly moved and second, all in favor?
Well, yeah.
Is there any discussion?
Well, we have to have a second.
Oh, it was Commissioner Newton.
Okay.
Doing it when you says it, Mr. Mayor.
Yeah. Sir?
I'm going to oppose this, and I'll tell you why. Those of you who were on the commission when this matter first came up, which has been, my goodness, 2 years ago now, something like that, it's been a while. It was a very divided vote, as I recall. It was a great deal of discussion. But we found probable cause and ended up going to DOA. And DOA has found all the facts to be correct, and they are correct. But when I look at some of the other impositions that we've had recently in much more serious cases for much, much less in money, and here's a situation, and we've had this come up more than once, where often the filing of a complaint is another arrow in the quiver of a political fight. This was all about local politics. This was all about people who didn't like the mayor and found a peg to hang the hat on by filing a complaint. Now, the advocate said that she purchased a PhD from a diploma mill, and I don't even remember the name of the college. It was one of those mail orders, but it wasn't like some of them where you pay a fee and they send you a diploma that says you have a PhD. You may recall, those of you who are on the commission, that she or her attorney brought her dissertation that she prepared, and it was about that thick. So she did a lot of work. It may not have been a real credible school, but it wasn't just you pay, they send a diploma. And she had it posted on the website. Now, that may not have been a real smart thing to do, but it was true. She had a PhD and had a diploma to prove it, and she put it on the web. I don't see that to be a serious thing. As a result of all of this, she resigned her office, which is exactly what the political opponents, and you see all their names here, intended by filing the complaint. So she got run out of office. She's now a private citizen. And given all of those facts, and given the fact we're talking about many thousands of dollars, I can't support it. The only way I would support it is to eliminate the fine and move for a public reprimand.
Okay. Commissioner, are you making that as a substitute motion?
Well, I'll be glad to, yeah,
Okay.
yeah.
Is there a second? Or is there any comments or discussion?
I didn't perceive anything about what he said as being a substituted motion. I perceived it as just argument on
Okay.
the motion that was at hand. So I can't tell anybody how to, handle their motion, but to me, it's just a comment on the motion that's on the table.
Sir, you're recognized.
Wasn't there also an allegation that, about another university that she said she attended, if I'm remembering correctly, that there's no record at that university that she ever attended there, or wasn't that in the facts somewhere?
Wait, let's have our advocate come and answer that.
Through the chair, on her dissertation, she wrote LaSalle University. The LaSalle University that's the legitimate one in Pensacola spells its name differently from the diploma mill in Louisiana, LaSalle University. There was those were one of the facts. Also, she did say that she got a sports medicine degree from, I think it was the University of Illinois. That could never be proven, but she maintained that she had that degree. And those are basically a fact. She did have a valid master's degree.
Mr. Chairman, a question, please, if it's in order.
Absolutely, but I will recognize our executive director. She wants to state something for the record.
LaSalle, you're speaking of the one in Pennsylvania as opposed to?
I'm sorry, yes, yes, in Pennsylvania, LaSalle, yes, thank you.
And before I recognize
And that's the
you-
legitimate one, excuse me, sir.
Yes, ma'am. Before I recognize you, did you have a follow-up, sir? Okay, you're recognized.
Thank you, Mr. Chairman. Anytime Senator Grant speaks, especially given his background on the commission, I listen carefully and respectfully. I'd like to ask the advocate to comment. My understanding after rereading the case from its beginning in preparation for today's meeting was that that this diploma mill, if we may use that phrase, was actually a place where you sent in some money and a piece of paper, maybe it was a dissertation, you got back a PhD, and that the diploma mill was actually closed down and the owner was taken into custody under criminal charges of fraud. Is that the case, ma'am?
Again, through the chair, yes, sir, that's accurate. I was prepared to have the testimony of the FBI agent who closed down the diploma mill. The owner of the mill was arrested and sent to prison, I think since he has passed away. The way that the operation worked was that there was one employee in one building. That employee had a GED. She did get a graduate degree, but that was from LaSalle University, the diploma mill. How these dissertations were graded, and this testimony would have come from the FBI agent, was that they were put literally on a scale, and the heavier they were, the better grade they got. And that's what I learned through my investigation of it, talking to the
May I
agent.
follow up, Mr. Chairman?
Yes, sir.
It was my understanding after rereading the materials that that the respondent was confronted with these facts and notwithstanding that insisted on holding herself out as having these fraudulent degrees. Is that the case, ma'am, or did I misunderstand?
That's accurate, sir.
Mr. Chairman, I agree that a lot of these matters start as political fights at the local level, and it's unfortunate that that our process is sometimes used to work out political grudges. But I do believe that the advocate has done a good job in this case of presenting circumstances in which the respondent did commit, did hold herself out to the public in a fraudulent manner. And when confronted with the facts, she continued to do so and insist on it. And then when given the opportunity to participate in a hearing to dispute these matters or to change the results of the commission's deliberations, she chose not to do so. And so consequently, I will support the motion, but I certainly have great respect for Senator Grant and understand his reasons for wanting to be sure that we have some consistency and fairness in our process.
Understood. Thank you. Members, are there any other further discussion? Yes, sir, you're recognized.
Thank you. I was not on the commission when the previous stipulation was rejected, and am curious if somebody can share with me the basis for that. Was it a belief that the proposed $5,000 fine then was inadequate? Does anybody know?
I will recognize our advocate. Go ahead.
The morning of the hearing, and we were prepared with our witnesses to proceed, she, through her attorney, wanted to enter into a stipulation, and at that time, we agreed to a $5,000 fine and civil, or as I said, public censure and reprimand. I brought that joint stipulation back to the commission. The commission rejected it, believing that the fine was too little, and the cases went back to DOA for a hearing.
All right, thank you.
You're welcome.
Are there any other discussions or questions? Yes, sir.
I do. These kind of cases are very disturbing to me. Having an earned doctorate myself, you don't get one in 9 months, start to finish, no matter how much paperwork you submit from any place. It seems to me throughout this case, when you read through the file, she substituted one fraudulent posting for another. When called on the University of Illinois Champaign being in error, she corrected that error and just posted a different error. My only complaint in all of this is that we can't go higher with the fine. She deserves more than $10,000.
Are there any other discussion? Seeing that it's been properly moved and second, let's move towards a vote. Let's go ahead and do a roll call vote, please.
Yay.
Yes.
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 No?
Yes.
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 All right, so it's passed and moved on. So now we move on to section 6. This matter is the consideration of the advocate motion to schedule matter. Adopt the ALJ's findings, recommend a penalty, and render a final order in complaint number 22-024 in re John Capps. This matter is before us for a final hearing because it appears that there are no disputed facts. This hearing will be conducted pursuant to sections 120.569 and also 120.57-2. Florida statutes and Rule Chapter 28-106, Florida Administrative Code. At this hearing, we will resolve any dispute issues of law and, if a violation is found based on the facts, to determine what the penalty is appropriate. Both parties will have an opportunity to present to the commission any oral or written evidence related to the complaint. If a dispute of matter of fact is asserted during this hearing, we will refer the complaint back to DOA. Each party will have 15 minutes to present his or her arguments, starting with the advocate. Commission members may raise questions at any time during the proceeding. Only testimony and evidence relevant to the complaint will be allowed. Members, you have a memo and a draft final order from the staff, as well as the advocate's motion include with all the relevant documents in this matter. Ms. Hanley, you are recognized.
Thank you. Respondent was an Orange County firefighter. This is the case where, subsequent to already having been suspended for concerns related to time and attendance issues by the fire department, he submitted false arrival times for work on a minimum of 4 occasions and therefore received a salary for time he did not work. As shown in my written motion to render final order, the evidence reflects that respondent violated section 112.3136 by using or attempting to use his position and/or public property or public resources to secure a special privilege, benefit, or exemption for himself. It has been deemed that respondent has admitted that he was a public employee who misused his position by acting in a manner inconsistent with the proper performance of his public duties to receive a special benefit, and that he received a benefit of salary that he did not earn, and/or attempted to avoid further disciplinary action to secure the benefit of continued employment. In my motion to render a final order, I'm requesting that the commission ratify and adopt the administrative law judge's April 14, 2023 order closing file and relinquishing jurisdiction, that the commission find a violation of section 112.3136 Florida statutes, that the commission enter a final order recommending public censure and reprimand, a civil penalty of $5,000, and $195.21 in restitution to the Orange County Rescue Department. Thank you.
Okay. Members, do we have any questions? Okay, seeing that we have no questions, members, do we have a motion?
I'll move the adoption of the draft final order prepared by staff.
Okay. Is there a second?
Second.
All right. So it's been properly moved and second. Is there any discussion? Yes, sir, you're recognized.
I have got to note the juxtaposition of this with the previous case and the fact that I continue after 6 or 7 meetings to struggle with any sort of balance. To me, this is worse than what the previous lady did. This is outright theft. I don't know what to do about that, but that's a concern to me.
Thank you. Members, any other discussion?
Mr. Chairman,
Yes, sir?
I believe that's a legitimate question, and even though I've been on the commission for a little while longer, I think, I'm sure the more learned members here will correct me. I thought it was Everett Dirksen who said that consistency was the hobgoblin of little minds, but I understood that he stole it from someone else. And so I wanted to ask General Counsel, if I could, to simply give us some advice or parameters, if you have them, about consistency of penalties, what we're obliged or not obliged to do, and how we may use subjectivity or objectivity in these matters.
In cases where there is a recommended order, there are certain rules about what standards by which you may modify it. This case does not have a recommended order with it, so those standards do not apply. There's a motion before you recommending a penalty, and then the draft incorporates that, but you are free to come up with your own penalty here. As far as the consistency matter, it's as commissioners, I think you all have a sense of what penalties you've been issuing over the course of your terms, and you have a sense of whether or not this does or doesn't rise to the level of what you've been doing before. I think this is defensible with our current precedents. If you wanted to increase it, I think that that's also probably in the range of possibility here, especially given the last cases, if your sense is that this is as or more or close to as severe. So that would be within your discretion to do. Nothing jumps out at me as necessarily prohibiting that, or I don't see any danger in doing that if that's the will of the commission.
Sir, you're recognized.
One of the big dilemmas as state attorney was the same problem, consistency in sentencing on criminal cases. The answer always was every case was separate. There were so many different facts that you could not have identical justice. And I don't know that there is ever a possibility of how we answer that other than individually and how we react to things. Many of you all have far more experience on this commission than me with trying to find a just sum. Maybe it's as simple as the attitude reflected by particular respondents when they go through a process that makes a difference with us. I'm going to support this. I just don't know how to reconcile the various differences, at least not yet.
Okay. Yes. Oh, before you go, go ahead. Go ahead, Commissioner.
Well, mine was for legal, and I was kind of pondering with consistency versus precedence. And you touched on it a little bit. Could you elaborate?
Sure. So if this was ever going to be appealed, working backwards from there, the question would be whether or not we have used our discretion in coming up with the penalty that we've come up with. Looking at that, we would have to look at a couple of things. Is the penalty within the range of the guidelines of the statute? So the penalty, you're fully aware of what the guidelines are and you're working within those parameters. Next, we would be looking at whether or not there is a precedent for the particular type of penalty. I'm not aware of any judge that would say that there is a particular dollar amount that is right to the exclusion of all other dollar amounts. So I think you're, based on what I'm hearing within the discussion, it sounds like the discussion is within a window that I think would be supported by our previous cases. If I hear anything that sounds outside of that, I would speak up and let you know, at the risk of trying to defend something that I didn't think was defensible. So those are the parameters. Regarding what I spoke about earlier as far as why you have that discretion in this particular case and not in other cases where there is a recommended order, there's a statute 12057-1L that says that with a recommended order that you can't modify the penalty unless you cite to the record with particular facts and demonstrate what the reasons for the modification. That's not in play here because, again, there isn't a recommended order in this case because all facts were deemed admitted due to the lack of the participation of the respondent in the process.
Mr. Chair?
Yes, sir, you're recognized.
As state attorney, one of the things I always did was give great deference to my assistants with negotiated pleas that they had come up with on the belief that they knew far more about the case than I ever could. Ms. Hadley is in the same position, and I'm going to support this because I give deference to her greater familiarity with everything that's involved in it.
Okay. Oh, Commissioner.
Just a comment from my reading, remembrance of the case. It seems like this particular respondent had a lengthy history of violating these time sheets and stuff. I think he'd been reprimanded by the department before for it, and then he continued to do it, and then basically continued he had a history of being a chronic liar and abusing the system. So I would be inclined to fine him more than the $5,000, but and then his lack of cooperation. If somebody comes in and says, "Man, I messed up. I'm sorry. Wish I hadn't done that," and of course they have terminated him, as I understand. Maybe he terminated himself. I don't know, but I would be in favor personally of a little more fine than $5,000 if we had the discretion to do that. So that's kind of my position.
May I ask a question? Just for my edification, what would that number be if you?
Well, personally, I don't think he's going to pay it anyway because he's paid no attention to the situation at all, and I think we'll end up. I can't remember how all of those fines that get put out there, how they end up getting paid, or what we do if they don't. Maybe that's a good question to ask. I'd say zap him with $10,000. I wrote on my notes after I read all of this stuff that you ought to be slammed. Slam is about all you can do.
Okay. Any other? Commissioner, you recognize.
Not with respect to this particular case, but with respect to the challenge of fines and penalties in general. In other parts of my life, when I've looked at civil fines, I've tried to create, in my own mind, a scale, perhaps on a 1 to 10 scale of the violation, 1 being extremely nominal and 10 being very egregious, or as Commissioner Meggs would say, the slammer. And so I would also use the dollars in the same way, which is easy on a $1 to $10,000 scale. 1 to 3 might be minor, 4 to 7 might be middle, and 7 to 10 or so might be more extreme. But that's simply my own personal mental evaluation of the case, and I'm not suggesting that that should be formalized in any way. What I think we all are thirsty for, though, is to be somewhat operating similarly in our evaluation of what the scale is. And so, because I think we do know what the guidelines are and we all have a gut, but what I lack is a memory or history of how we have applied it over time and what my own scale has been. And so that's what I see going forward, is to establish more consistency on my own scale of evaluation.
Okay.
Another question.
Commissioner.
So if the advocate every time got up and said, this is a 3 or a 7 or a 10, I would know exactly what to do. And so I am sort of suggesting that we, in our own minds, define major or minor and reflect our scale going forward in that way.
Commissioner, you're recognized.
Just back to legal, do we have a, I heard the word defensible, do we have a range of what might be defensible?
So, I wouldn't dare throw out any numbers here, that's, until one day when I get to sit where you're sitting, I don't get to do that. But the range that you have is certainly anywhere between 0 and 10,000 as far as what's within the range of what you're allowed to do. As far as the range of where you're bound by precedent, I don't necessarily have an instinct there. I would say in general, if everything is 10,000, then nothing is, then nothing is, right? If they're all at that level, then I think it becomes very difficult to distinguish. If you feel that 5,000 is inadequate, then what I'm telling you is you do have the ability to go higher than that. It's kind of in your discretion as to what you want to do.
Can I read it?
Sir, you're recognized.
Let me answer differently. You stated that case study would determine precedence. So has there been something similar in your recollection, because I'm new to the commission, that garnered maybe something north of the $10,000 without saying no?
The memory, the institutional memory as far as what the penalties have been, Melody is really great at that. I would defer to her.
So the case closest to this would be a case with Renee Lee. She was a Hillsborough County attorney, probably around the year 2012 maybe. And at that point, she issued, I'm trying to give you the short version, she issued an opinion where she received a raise, and it was supposed to go through, any raise that she received was supposed to go through the Hillsborough County Board of County Commissioners. So we went to trial, she ended up receiving a $5,000 penalty along with public censure and reprimand. I believe the most she may have received in that raise was almost $1,000, $1,200, something like that. It was, Mark Herons was opposing counsel in that case. So to me, that's the case that's similar to this. She was a public employee who received funds she shouldn't have received in the form of salary. And again, that was in 2012.
Members, any other discussion?
Thank you.
Yes, sir, you're recognized.
In that case, did she do it one time or did she do it multiple times?
That was one time issuing an opinion. And like I said, she received almost somewhere between $1,000 to $1,200. Mr. Capps here received $195.21.
In this case?
Correct.
But he had a history of doing it previous to this.
He had a history of time and attendance issues. I don't know if those issues were the same as this issue, as far as reporting the wrong time. I'm not sure if he did the exact same thing in his first discipline with the fire department.
Sir, you're recognized.
I assume that you were aware of and factored that prior case into your deliberations with coming up with this recommendation.
I was the advocate on that case as well, yes.
That's exactly one of the reasons why I would always give deference to my attorneys when I was a prosecutor, that kind of background.
And I do take into account the range we had with the seriousness.
Mr. Chair.
Commissioner.
Just another question. So the only difference is, between the two is, she received public reprimand, and this gentleman fell on his own sword and got terminated.
I'm Sorry, there was a little noise from the background
I'm
for your
saying
last part.
the young lady you're referring to received a fine and public reprimand. This gentleman is already terminated or resigned or something like that. That's the only difference.
So she received a public censure and reprimand and a $5,000 penalty. In this case, Mr. Capps, he was terminated from his employment, so he is no longer a firefighter. And the request was for a $5,000 fine and public censure and reprimand, and restitution to pay back the funds he received from false times.
That was my next question. I was going to ask you, was any clawback in there for the money that was paid for?
Yes.
Thank you.
Yes, sir, $195.21.
I'm good.
Members, any other discussion?
You're looking at me.
Yeah, you look like you got something you want to say.
I'm just pondering on this because, I hate to Roy Bean this, but, I think on most of these cases, we ought to max the fines because I was happy to see with this past session that they increased them.
Right.
But the actions of these people that come before us cause us to incur huge public costs. The costs of these proceedings, the costs of the attorneys are much higher than $1,000 or $2,000. And part of the fine to me is a deterrence also to other people not doing this misbehaving. So, on any of these, when you have an issue of consistency, to me, the easiest consistency is just to max every one of them so that they don't come back before us. And so, I'm not bothered about 5,000 or 10. And in many cases, you're right, Commissioner, that we're probably not going to collect it. With some of these people, they just kind of fade away and then you end up with a list of unpaid fines. But as a board member, as a commissioner, I think, what was the term you used? Slamming, I think?
Something like that.
Yeah, I think slamming is in order.
I'd like to recognize our executive director.
There's been some question about collection of these fines and the advocates in cases of complaint proceedings and complaint civil penalties. That responsibility falls to the commission advocate. They go to court and get a judgment when need be, when they can't track them down. It's a different process than for the automatic fines for the financial disclosure, the statutory fines there. The advocates may be able to speak more completely as to what they do when they go and get a judgment, but I believe they get the judgment for the amount of your penalty as well as costs incurred to get that judgment.
Thank you.
Mr. Chairman?
Yes, sir.
Also, it's not particularly relevant to this case because the gentleman in question is no longer a public employee, but the legislature did at a previous time adopt legislation to give this commission the opportunity, and I believe we use it, Madam Executive Director, to collect fines from the salaries of public employees. And we can take up to 10% of their public salary in order to satisfy these fines. And the reason why those of us who served at the time voted for it was to give this commission some teeth, because in the past there was a history of this commission imposing fines, whether they were 1, 2, 5, or 7, and everyone just sort of writing it off as a cost of doing business for which there was no consequence. So I think we have more teeth now in collecting fines, maybe not as much as we would like, or as I would like, but we can go after the partial payments out of the salary of public employees till that's satisfied, and we can get a judgment. And if you want to get a car loan and you got a judgment against you by the Commission on Ethics, it does create a little bit of a problem in your life.
Okay. Yes, ma'am, you're recognized.
Salary withholding has been an excellent tool that the commission has been given in terms of collecting the automatic penalty for financial disclosure fines, that $25 a day fine. That does not apply to the collection of civil penalties for complaints, however. If that's something you all wanted to explore in your legislative recommendations, when we talk about those very soon, probably a worthy discussion because it's been very, very successful. Something that the legislature gave us for the for those financial disclosure fines.
Okay. Members, any other discussion or question? Seeing none? All right, let's bring this to a vote. All in favor, say aye.
Aye.
Oppose? Seeing none, it's properly moved. All right, moving on to the next item. Now we're on number 7. We have before us a request for attorney fees and costs filed by Teresa Caverda, the respondent in complaint number 22-077. Ms. Caverda's petition seeks to have the complainant, Mr. Juan Carlos Plantas, pay attorney fees and costs following the dismissal of the complaint filed against her. We have copies of the file in this matter and of the staff draft order denying the request. At this stage, we will vote to determine if the petition is legally insufficient and dismiss it as recommended by staff, or find the petition is sufficient and should be sent to the Division of Administrative Hearing for a hearing as to the cost and fees. Is Mr. Caveira, Mr. Plantas, or their legal counsel present?
Mr. Chairman, good morning. Adam Cervera, the law firm Becker and Public Health, on behalf of Ms. Cervera, present for the chambers.
Okay, awesome. The Commission Staff Attorney, Kathy Hayward, will summarize the staff recommendation on the petition. Then we will hear from Ms. Caveira and her attorney, followed by Mr. Plantas and his attorney. The parties will be asked to limit their remarks to 15 minutes each. After that, the commission members are free to ask questions of either party or our staff. Kathy, you are recognized.
Mr. Chair,
Oh,
before we go,
wait.
just a
Oh, yes.
disclosure, I served with Mr. Planis in the Florida House of Representatives. However, it will not impact my decision today.
Okay, thank you.
Mr. Chairman,
Yes, sir.
I served with Mr. Plantis in the Florida Legislature in the House of Lords. He was in the House of Commons, I think. But I don't believe that will affect my deliberation in this matter.
Okay.
Mr. Chairman,
Yes, sir.
I didn't serve with him.
Okay, all right. So with that said, there's no more disclosures. Ms. Kathy, you're recognized.
Thank you. Catherine Hayward, Staff Attorney, and thank you, Mr. Chair. At the time the complaint was filed, Teresa Cervera was a candidate for Circuit Court Judge in the 11th Circuit in Florida. You recently dismissed an ethics complaint as amended, filed against her with a finding of no probable cause. After the case was dismissed, Ms. Cervera filed a petition for fees and costs with the commission. That's the first step for recovering attorney fees and costs from the individual who filed an ethics complaint against her. The complainant is Juan Carlos Plantis. Essentially, the complaint as amended that was filed against Cervera alleged that when qualifying for her election for Circuit Court Judge in the 11th Circuit, which requires a filing of a 2021 Form 6, full and public disclosure of financial interests, requires that as part of the paperwork, Cervera failed to disclose or inadequately disclosed her assets and liabilities, particularly the assets she used to loan her campaign $100,000 and a mortgage line of credit on her parents' home on which she was listed as a borrower. Both of these allegations were possible violations of Article 2, Section 8A, Florida Constitution, and Section 112.3144 Florida statutes. The Code of Ethics allows respondents to ethics complaints to seek attorney's fees and costs from a complainant in certain instances. We have a rule that lays out the process for recovering attorney's fees and costs, which is Rule 34-5.0291 in the Florida Administrative Code. It states that a respondent must file a petition for fees and costs within 30 days of the dismissal of the complaint, and that the petition must state sufficient facts and grounds to prove one's entitlement to attorney's fees and costs. If the commission determines that the facts and grounds in the petition are legally sufficient, it shall refer the matter to DOA for an administrative hearing. And if the commission determines that the facts and grounds in the petition are not legally sufficient, it shall dismiss the petition. And that's the task you have before you today, to determine whether the petition is legally sufficient and should be referred to DOA, or whether it's not legally sufficient and should be dismissed. Section 112.317, subsection 7 of the Florida statutes lays out the standard for determining whether a respondent is entitled to recover attorney's fees and costs from complainants. There are several elements that must be met in order to find a complainant liable for attorney's fees and costs. The first element is that the complaint must be filed against a public officer or employee. We'll come back to that later. The second is that the complaint must be made with a malicious intent to injure the public officer's reputation. Third is that the person filing the complaint must know that one or more of the allegations about the official are false, or must file the complaint with reckless disregard for whether the complaint contained false allegations. The fourth required element is that the false allegations must be material to a violation of the Ethics Code. This standard is not a prevailing party standard. It's a high bar for recovery, and the reason for that is because the intent is not to discourage complainants from bringing complaints that allege facts that are true and material to ethics violations, even if some of the immaterial details are false or simply can't be proven to be true. The law doesn't demand that every word and every detail written in a complaint be verifiably correct or objectively true. The Commission legal staff recommends that you dismiss Cervera's petition for attorney's fees and costs. Okay, going back and looking at the statute with the criteria that must be met to have an award of these, Section 112.317, subsection 7, the first criteria is the complaint must be filed against a public officer or employee. Ms. Cervera was not a public officer or employee when she filed her Form 6. She was only a candidate. Therefore, she is precluded from receiving any award for costs or fees because she does not meet the first element of the statute. Okay, so one needs to go no further into the merits of the petition for fees and costs. While there's no need to go into a discussion of whether the merits of her arguments would be legally sufficient to state a claim for fees and costs, the draft does continue with a discussion of the merits of Cervera's arguments. Commission legal staff concludes that the arguments in the petition are not legally sufficient to state a claim for fees and costs under the statute, and we recommend that the petition for attorney's fees and costs be dismissed on the merits as well. And the draft fully explains the reasoning of that. You're not obligated to adopt this draft order. It's just a document communicating staff recommendations to facilitate your consideration of the matter. And I'm available if you have any questions or if you'd like me to go further.
All right, any questions? Yes, sir, you're recognized.
Thank you, Mr. Chair. So normally in a situation like this, if there's no subject matter jurisdiction, which it appears there is no subject matter jurisdiction, we wouldn't even go into the issue with the merits. We would just state that. How come you went beyond that here to address the merits of the argument?
Through the chair. You're exactly right. Just as an added reason, we address those that it would fail on those on merits as well.
She did that at my direction. In reviewing this, obviously she's not a public officer or public employee, which is the first element of this. To button it up, we also, in reviewing the merits, we felt that the merits plainly failed, and we recommended that in the draft. We thought it was important to point that out in addition, so that there were multiple reasons for finding this petition to be legally insufficient.
Follow-up. So though they haven't presented yet, and I'm certain they're going to have an opportunity, I've got to believe that they're going to look at this in terms of why we're wrong and we do have subject matter jurisdiction. Because if we don't have subject matter jurisdiction, we can't do anything legally anyway. So I guess wait to see what their argument is for subject matter jurisdiction.
Okay. Any other questions? Thank you. Would Mr. Severa and their counsel come forward for your presentation? Yes, sir.
One further disclosure, I guess, at this point. I am a president of a homeowner association, and Becker Polyakov is our attorneys.
Okay.
So I just thought, of course, that won't affect my decision. Thank you.
You're in good hands, Commissioner.
I believe so.
Good morning again to the Commission. My name is Adam Cervera of the law firm Rebecca and Polyakov, and I have the distinct pleasure of representing Mrs. Teresa Maria Cervera this morning before the Commission. Before I want to get started, I do want to take this opportunity to thank the Commission for giving us an opportunity to be heard.
Mr. Chair, he gets 2 minutes. Clock's still running.
No, he gets 15.
It's been reset now. It was 2 minutes. Yeah,
Thank you, Commissioner Newman. I wasn't even looking at the clicker here. Thank you. I appreciate that. I also want to thank Ms. Hayward for her efforts in drafting the proposed order and her work on this matter. However, Commissioners, it is of the utmost importance that this order be rejected. If this Commission accept this order as drafted, you denying the fee petition, we're sending a strong message that is entirely permissible for political opponents and their staffs and their supporters to essentially weaponize this Commission to influence the outcomes of elections. Commissioner Grant mentioned this in one of the early hearings this morning. This is often one of the tools in the proverbial bag that is used. Let's be clear. In our situation, Mr. Planas filed not one, but 2 complaints before this Commission, both of which were rejected, and an order was entered on that several months ago. These were attempts to influence the outcome of Ms. Cervera's judicial race. I know this because if you look at the complaints on their face, they contain false allegations, which are literally negated by the very exhibits that are attached to the complaints in both cases. These complaints were not filed by a quote-unquote concerned citizen. These were filed by a lawyer and a friend of Ms. Cervera's political opponent in an effort to influence her election outcome. In fact, Mr. Planas has a history of filing these types of ethics complaints. On my tally, it's up to 20 to date that have been filed before this Commission. So this isn't a one-off situation. Mr. Planas knew that all he had to do was file these bogus complaints. He can go online in a public and virtual forum and then tell the world how terrible this candidate was and why she shouldn't be elected, why she was unelectable. If we accept this proposed order, we are sending a message to all prospective candidates in this state. And even though those folks who may be thinking about running at a later point in time, that you will be subject to potential ridicule, to disdain, to false allegations, and there's nothing you can do about it. You have no recourse. And quite frankly, if the order is accepted, that's what's going to happen here. Now, I want to address the public officer, public official dispute. This is a finding that is made in Ms. Hayward's order. First and foremost, she takes the position that there's no jurisdiction and that we cannot seek relief under 112.317 because Ms. Cervera is not a public officer under the statute. Key phrase, public officer. However, it's our position that this argument fails for several reasons. This is the first. The term, if we look at 112.317, the term public officer is not defined in that statute. I've got copies of it. I'm sure the Commission is very well versed in that, and I'm sure it's in your packets. But if we look at the actual statute, 112.317, and any of the subsections, the term public officer is not defined at all. And this is important, Commissioners, because the case law will tell you that when you're looking for statutory interpretation, whatever construction is given to certain language in one part of a statute would necessarily also apply to the same phrase in another portion of the same statute. And that's from the Florida Supreme Court in Stevens versus Winn-Dixie, 201 Southern 2nd 731. This is relevant because if we look at other portions of 112, like for instance, Section 112.3125, the term public officer includes candidate. So we have other portions of the same statute, of Chapter 112, in which public officer is inclusive of the term candidate. In 112.317, public officer is not defined, it's silent. So we don't know what it means. So the case law will tell us we have the ability to look at other portions of the statute and look no further than 112.3125, in which public officer includes a candidate. Now, let's also address this from a practical standpoint, a common sense standpoint, a legislative intent standpoint. Although we believe that Ms. Rivera is in fact a public officer under the case law, when you can look to other portions of the statute, if you hold candidates to the same standard as elected officials, when it comes to their filings, when it comes to their reportings, when it comes to their Form 6s, they're equal. Even Stephen, everybody's on the same page. Everybody's expected to do the same thing. Yet, if you are a candidate, somehow you are barred from seeking the same recourse than an elected official. Even if a complaint is false or malicious or targeted at you to influence your election, no recourse. The entire intent and purpose of 112.317 is to protect against improper attacks and false filings and levy penalties against those who violate that statute. It is patently inequitable and unfair to hold candidates to the same standards in every other phase of their election, except the end. And that is exactly what this order will allow to happen. And quite frankly, this discourages people from running. Why go through this process? This was a judicial race. This is supposed to be, the G-rated version of politics, right? And look what happened in our case. Ms. Rivera was attacked from every which way, and now she has no recourse if you accept this order. Now, I want to address some of the allegations in these complaints, Commissioners, because this is important, and I want to start with the first one. In the first complaint, Mr. Planas focuses on Mrs. Rivera's quote-unquote inability to lend herself the $100,000 that she lent herself for her campaign. However, once again, if you look at the exhibits that are attached to this, the exhibits negate the allegations in this complaint. Specifically, within her Form 6, Commissioners, Ms. Rivera lists one mutual fund account in the amount of $41,000, one money market account in the amount of $22,000, one checking account in the amount of roughly $50,000, and 3 IRAs. This is important. 3 early retirement accounts that total $35,000, $36,000. The total combined amounts for all of these accounts was $150,000 when you add up all of these. Mrs. Rivera lent herself $100,000. Out of the $150,000, she lent herself $100,000. And in doing so, she drew from her checking account, she drew from her money market account, and she drew from her mutual fund account. She never drew from her IRA, any of them. There was 3 of them. She never touched them. Despite this, within the first complaint, Mr. Planas alleged that in order for Rivera to have loaned herself the $100,000, she would have needed to liquidate all of her retirement accounts. That's the quote. All of her retirement accounts would have had to have been liquidated. This was a lie. This was a false statement. A 3rd grader with the most basic understanding of math and math skills could have looked at Rivera's Form 6, realized she had more than enough money in her mutual funds accounts, her checking accounts, all the other accounts that were not early retirement accounts, that were not IRA accounts, and could have seen that she would not have to liquidate her IRA. And that's exactly what she did. She drew from everything else but the retirement accounts. The math was simple. There was enough money to loan herself the $100,000 without touching the retirement accounts. Yet Mr. Planas alleged that she would have had to liquidate all of her retirement accounts, in order to fund her campaign. Money don't lie. The money is what the money is, and the numbers are what the numbers are. Plinus knew this, yet in his complaint, he still opted to make this false allegation about liquidating all of her retirement accounts. In the second complaint, we deal with a line of credit agreement that was taken out by Cervera's parents in a different county from that where Mrs. Cervera lives and where she ran. And Mr. Plinus claims that this was a financial liability of Mrs. Cervera that she failed to disclose on her Form 6. However, here's where it gets interesting. Mrs. Cervera was never a party to the line of credit, nor did she ever sign same. She actually didn't even know about it. Her parents did it. She didn't know about it until the ethics complaint came in. In the second complaint, Mr. Plinus makes the following false allegations. Quote, Ms. Cervera co-signed, signature, a line of credit on her parents' home, and Mr. Cervera's husband was also a borrower on the subject line of credit. Both of these statements were false. Look at the exhibits. They're attached. Look at the line of credit. Ms. Cervera never co-signed any line of credit agreement. Mr. Cervera's husband was never a borrower on her parents' line of credit. Mrs. Cervera's husband's name does not appear anywhere on that line of credit agreement. And again, to make matters worse, if you look at the exhibits, the line of credit agreement is there. You can see all of this. Yet despite that, despite the exhibits negating the allegations of the complaint, these were filed. Just like the first complaint, the second complaint was nullified by the exhibits which were attached. Again, even the most basic review of the exhibits would have led any person with common sense to realize that the allegations were false. Now, as I work towards my conclusion, Commissioners, I want to address the real reason why I believe we're here today. The real reason that these complaints were filed against Ms. Cervera is because Mr. Plinus wanted to destroy her reputation with these complaints and ensure that she didn't win her election. That's my true belief. And he needed to file these complaints so he could go on TV, so he can go on Facebook, so he can go on Twitter, so he can go to the Miami Herald and go to all of his outlets and say, hey, look how terrible this candidate is. She's got complaints. Look at these complaints over here. He wanted to get his client and his friend, Mrs. Cervera's opponent, elected. That was his goal. That is my belief. Now, we know that this commission is permitted to look outside of the four corners of the complaints that were filed in making a determination as to the ill will and malice aspect of these filings. And look no further than Mr. Plinus' social media accounts. In numerous Facebook postings made by Mr. Plinus during the election, he attacked her. He accused her of violating ethics rules, of judicial conduct, of lying. This is all in publicly available social media posts. They're attached to the petition as Exhibit C, I believe. Mr. Plinus creates the scandal with these false complaints and then uses them to attack Mrs. Cervera online. These social media posts were not those of a mere quote-unquote concerned citizen. If we actually look at the response to the fee petition that Mr. Plinus filed, he gives an interesting quote. He says, Mrs. Cervera's explanation of how she lent herself the money was not a likely scenario among those who consider themselves, quote, intellectually worthy to sit as members of the judiciary. It is clear that Mr. Plinus did not like Mrs. Cervera. And in addition to these social media posts, he routinely made comments to the media, as well as holding a televised press conference several days before the election in front of a polling station in which he went on to grade and blast Mrs. Cervera. As I conclude, I do want to thank the Commission for your time and for your attention this morning, and I want to leave you with the following. The mere fact that all of these allegations in both the first and the second complaint were negated by the exhibits, coupled with his conduct outside of the complaints, proves that he had malice, proves he wanted to influence the outcome of this election. And the proposed order, there's a quote in there that states that, quote, "The petition does not demonstrate how Planas would have known the allegations were false." Respectfully, this statement is just flat out wrong. Every single allegation is negated by the exhibits. If you just look at it and you just read it, you can see it. Sadly, Mr. Planas' tactics were successful. Ms. Cervera would go on to lose an election, a close election, but she lost the election, unfortunately. And I also note again that Mr. Planas is not a mere concerned citizen. This is a licensed lawyer who served with members of this commission as an elected official. He specializes in election law and ethics. He's a professor of law at St. Thomas University College of Law, where he teaches students law and ethics. This is not a concerned citizen. This is someone who knew very well what he was doing. Just like the other complaints that he filed, he will continue to weaponize this commission unless there are repercussions. So I'm asking this commission to reject this proposed order. I'm asking this commission to hold Mr. Planas liable, and I'm asking this commission to send a message to all of those future candidates out there that if you run and someone drags you through this process improperly, you can come back and you can seek recourse. I thank you, and I'm happy to answer any questions the commission may have.
Okay. Members, any questions? Commissioner, you're recognized.
To the order, so is your understanding that candidates are public officers?
Is this to me, Commissioner, or to Ms.?
No, to you.
Okay. Here's my position.
I'm questioning what you just said.
Sure, understood. So here's my position on the order aspect. The statute says what it says. The statute also has different sections. We know 112 is a very large statute in which public officer is specifically talked about and incorporated in different circumstances. In the relevant statute issue 112-317, public officer is not defined. And that's important because in other portions of the statute, when they talk about public officer, it includes candidate in the definition. And when you don't have a definition in the specific statute that you're looking at, the case law says that you can look to other portions of the statute to find meaning. And when you look to other portions of the statute, you find that public officer includes candidate. And I think also, Commissioner, it's important to understand the legislative intent, which we could also look to when we're trying to find meaning in statutes. The legislator drafted 112-317 to punish and provide recourse when people are wrongfully accused. You should not be discriminated simply because you're a candidate. You should not be held to the same standards as everyone else through the entire process except for the end. That's inequitable.
Okay, my query with that is that I was a legislator, and I don't never want to legislate from the ethical bench here. And I don't think, in fact, my class and my speaker in our legislature frown when the Supreme Court legislated from the bench, because the law is the law, it's the statutes. Now, public officers is someone who's a recipient of public funds. They're receiving tax dollars, they're working for the public. That's, I think, was the intent when that was drafted, not just someone running for office. But I want to move on, because I know my other colleagues may have questions, but you
Sure.
something else you said, another thing I took down, you said something about her parents did it and she was not aware of it, she didn't know. What you meant by that when you said about something on the phone?
So here's what happens. Her parents, who live in Broward County, Ms. Cervera lives in Miami-Dade County. Her parents live in Broward County. They take out a home equity line of credit, right? And the document for that, the loan documents for that, are signed by the parents. The parents own the home. Ms. Cervera does not own the home. Her parents own it. So the line of credit documents are signed and they're filed in the public record. Now, Ms. Cervera has a remainder interest in the property, meaning when her parents pass, she and her brother, her sibling, will inherit the home. So when Mr. Planas, I guess, pulls the deed for the house, he sees, oh, Cervera has a remainder interest, which again, doesn't vest until the parents die. So legally, Ms. Cervera has no interest in that property until her parents die. And he just makes this large assumption that because she has a vested interest in this property, that she is involved in this home equity line document. The problem is, and the false statement that's made in this, is Plana says that Cervera co-signed the line of credit. The line of credit document is attached, Commissioner Newton. Her signature does not appear anywhere on that document. And what I said why she didn't know about it, her parents took out the home equity line. They recorded, they used their lawyers. She wasn't involved. She had no idea that her parents did that until she got the ethics complaint and called her mom and was like, hey, what is this? And she explained what happened. And then we had to kind of, figure out what was going on.
My next question is,
Sir.
So she's not a par, she's not liable for this?
Absolutely, 100% no.
Okay, so she did, well, okay. Now, your last statement was, you just made this, you said the petitioner, as to the complaint, you said he knew the allegations were false. Well, how would he know the allegations were false if she didn't even know it was done? How does that work?
Because if you read the way she figured out the allegations were false, other than speaking to her parents, is looking at the document and saying, I never signed this. The allegations were Cervera signed the line of credit. The line of credit is attached to the complaint. She never signed anything. So unless Planas just completely ignored the exhibit, which I highly doubt based on how the history of this has gone, the exhibit negates the allegations of the complaint. And if you attach an exhibit to a complaint, you consider everything as a whole, and you are deemed to have understood what was in the exhibit.
Commissioner.
Sure.
Are you, because there's another.
I was trying to get an answer to my question. So when he filed a complaint, he knew that she wasn't a co-signer, is what you're saying?
Yes, sir.
Okay, thank you.
Commissioner Gates, you're recognized.
Thank you, Mr. Chairman. I'd like to ask a question, General Counsel, if that's appropriate.
Yes.
Before we get into all of the other topics that Council has raised, what my understanding of the presentation of legal staff is that the rock upon which all of that perishes is the question of public officer. Anytime anybody talks about legislative intent, it always brings a smile to my face because, you can find a lot of variation in legislative intent on the same topic among people who serve together and even sponsored and co-sponsored the same bill. But Council, would you please advise us as to the strength or lack of strength of the public officer argument? And I don't mean this in any pejorative way, but the sort of gymnastic that Council engaged in. This is new to me, that a public officer is a candidate and a candidate's a public officer, but I stand to be instructed, and Council, could you instruct us?
To be clear with what I'm about to say, I am not the attorney for Juan Carlos Planas here. I'm not making an argument in defense of his petition, and in fact, there's a substantial amount that I agree with what Mr. Cervera has said about the potential maliciousness of the complaint. On the argument about public officer, he points to one particular provision in there that has a definition of public officer. It's 112.3125, which is the prohibition against dual public employment. The first couple of words of that prohibition are, for purposes of this section, it defines a public officer to be, and then it includes candidate in that definition. It does that because that is the exception to the rule. It's not there are a few things that I would point you to aid you in your understanding of what a public officer is. First is your probably intuitive understanding that a public officer is somebody who holds public office. If this particular respondent, Ms. Cervera, if she had been a public officer, she would have been a judicial public officer, which is somebody you don't have jurisdiction over in the first place. So she wasn't a judicial officer. She didn't wield any power of the sovereign. So that's the first part of understanding that I think we need to understand here. The second thing is there are provisions in the Code of Ethics, way more of them, that do define what a public officer is for other particular provisions. To get into those, you would look at section 112.313 defines a public officer to be a particular person. It doesn't include a candidate. Article 2, section 8F2, which we have the 8F, which is the lobbying ban in the Constitution that is now subject to the litigation that we've been discussing. That has a definition of public officer. It does not include a candidate. Earlier in the Constitution, Article 2, section 8B has a definition that distinguishes a public officer from a candidate. So there are other places where this is not the case, and those other things comport with your general understanding of what a public officer is. The reason the section that he cited is different is because that's the exception. So those are the things that I would say about the public officer argument. The other thing that I think is important to note about the line of credit, if I might, there is case law out there, and I wish I was so warm on it that I knew the names of these cases. But one of the standards by which you can judge whether or not somebody knew something was false or was disclosed with reckless disregard for the truth is whether or not they took any effort to investigate whether or not the fact was true or whether or not the fact existed. And in this particular instance, he's attached to the complaint, the line of credit documentation. This was attached to the complaint amendment. You have that in your materials in the complaint amendment. Page 17 of the PDF is Schedule A of that document, as Schedule A of the line of credit. And I think this is what he was pointing to. It lists several individuals, including the respondent, as a borrower. Now, I think there's some liberty taken here because the word that he uses in the complaint amendment is cosign. She's listed as a borrower here, and I think that's the reference that he's making in the complaint amendment. I don't speak for him. That's what we took it to be when we were, as staff, were reviewing the document and tasked with making a recommendation here. So in making the recommendation that was made, there's a document here that says the respondent is a borrower. The ultimate investigation, which was found to have resulted in no probable cause finding by you, found that indeed she hadn't co-signed it. She hadn't actually co-signed the document. She hadn't signed anything. But as we laid out for you in our presentation about the draft, this isn't a prevailing party standard. It doesn't matter necessarily that the fact ultimately was found to be false. It's whether or not he knew at the time, based on the information available to him, that it would have been false. We, in the draft, proposed that standard's not met. Obviously, there's a disagreement here, but that's the law around what has happened here, what we're presenting to. I hope I've answered your question. If you have additional questions, I'm available for.
Mr. Chairman. Yes, sir.
Mr. Chairman, I'm persuaded by counsel's arguments that, if I may use a phrase only of my own, that there was an abuse of the process here by the person who brought the complaint. I understand how difficult that abuse can be. Senator Grant made a comment earlier about another case that I think pertains in a lot of situations where people abuse the process of this commission, and because of the rules that are established, the laws that we operate under, you have a very hard time defending yourself if your response to a complaint that is really abusive and specious. I know, I've been there, but I can't get over the definition of a public officer. So, Mr. Chairman, I'd like to be quiet and listen to competent counsel on this commission. We have some esteemed attorneys here who may be looked at this in more detail than I, as simply a former legislator.
Okay. Members, any other questions?
No question. I do have a comment when we get to this.
Okay. Any other questions? All right, thank you, sir.
Commissioner, may I respond to Commissioner Gates's inquiry?
Sure.
Okay. I want to make sure to the commission that I'm being 100% clear on my position here. I'm not arguing with counsel, and I'm certainly not arguing with the text of the statute. I realize that in some portions of the statute it says one thing, and in some portions of the statute it's saying another. What I am suggesting to this commission, that if you choose to take action, which I believe you should, I believe you have a basis to allow this petition to go forward based on the case law, which clearly says that if there's a portion of the statute in which a definition is provided, and there's another later portion of that statute in which it's not, you can look to other portions of the statute to interpret that definition. We have a clear statute, 112-3125, in which public officer includes a candidate. If you want to adapt that portion of that definition from that portion of the statute, I believe you can, under the case law, to make it applicable to 112-317. And if you want to set a message, and if you want to have candidates to have the ability to seek recourse when they are attacked, when they have to deal with these false and malicious complaints levied against them, I believe this commission has the ability to do that. And if the legislator wanted to specifically define whether or not candidate included public officer within 317, it could have done that. It chose to stay silent. There is no definition of public officer in 112-317. Therefore, Commissioner, you can look to other portions of the statute, 112-3125, in which it is included, and you can accept that definition and understanding if you choose. Thank you.
Thank you. All right, members, we're now at the portion, we've had questions. Is there any discussion? So we're on the discussion. Well, no, there's not a motion, right? Okay, awesome. Yeah, we got rules. So discussion. Commissioner Meggs, you're recognized.
I've listened very carefully to everything that's been said, and I think we have a unique situation here because I'm looking at across the room, we have 4 excellent lawyers over here, 2 excellent lawyers here, a good lawyer here, and apparently a candidate lawyer over here. And I think the solution, a good solution to this problem is there seems to be an issue, there seems to be some maliciousness in this case. What I think we ought to do is allow this case to go to DOA, where we have a judge who can hear all of these arguments. People can go to our lawyers, their lawyers, bring the cases, do the research, get a judicial ruling, which will have a record that could be taken up on appeal, and we can have this issue resolved so we don't have to come back. Today's my last, my term expires today.
That does not matter.
That doesn't.
You're stuck. You didn't know about the lifetime indenture?
But hopefully the next commission would not have to have a ambiguous situation, because this situation is bad. And the solution to this situation is have a court resolve it with an appellate. If they want to appeal, they can do that, and I would not be in this position if this were a county commissioner running in Lafayette County, I believe you call it, Bill, that worked at the hardware store and didn't have the means to handle an appeal. But I think these folks are capable, and they're capable of presenting a case in court, and that's where it needs to be, not us sitting as a court, because I don't practice law anymore, and I'm not a good judge. So that's my comment and my recommendation about what we ought to do.
All right.
Mr. Chair?
Yes, sir.
Just to be clear, because I saw Commissioner Meggs motioning towards the advocates about taking this matter to court. The advocates wouldn't be a party in this particular matter. It'd be the respondent and the complainant would be the parties at the DOA proceeding.
Okay.
Well, they're lawyers too.
Sir, you recognize.
Thank you, Mr. Chair. So, from a procedural standpoint, because that sounds like a good solution to this, because what I think we're being asked to do right now is determine whether or not the interpretation of public officer includes a candidate. And I don't know that we're in that position to do it. It'd be a lot better if we had a judge to look at it. Certainly makes sense in this case that it would, because why would you only give a public officer an opportunity to protect themselves as opposed to a candidate in the same race? It doesn't make sense, and of course, but getting back to what Senator Gates said, who knows what the legislative intent was? It doesn't make sense from a standpoint of looking at it. Everybody, if you're a candidate or a public officer, you ought to have the same opportunity to recover attorney's fees for a case that's brought maliciously or with reckless disregard for the truth. So, that being said, if the proper posture is for us to send it to DOA, then I would be in agreement with Commissioner Meggs that that's more appropriate than for us at this point to determine the definition of the statute in play here.
You're wise beyond your years. All right, any other discussion? Yes, sir.
Yeah, just like I was saying earlier, and what bothers me is that when you talk about public officer, you're talking about individuals or recipients of public funds. If you receive public funds by any means, you work for the public, which makes you an officer of the public. Sanitation worker, council member, county commissioner, legislator, judge. If you receive public funds, you're indebted to the public. They put a trust into you. Once you reach that plateau, if you win, you get sworn in, or you get that job and you receive public funds. From our attorneys, everybody that's employed here is recipients of public funds. And that's what the legislation intent was, if you ask me. I don't have a problem with interpretation, because if you take the argument that's put before us, every candidate, thousands, if not millions, that ever ran are public officers. And how could they be? None of them receive public funds. No candidate that I know. There's one right now receiving public funds, and that would be the governor. He's a candidate for president, and he's the governor of Florida. That's the only one I know of currently in the state that's doing both. Normally, a candidate, for instance, my LA was running to precede me after I got out the council, got out the legislature. And she immediately had to resign. We have laws in effect that if you're employed by the state and receiving public funds, you have to resign and run. You can't get it both ways. And she had to immediately resign and forfeit her benefits and everything else to run for office. So she was not beholden, I don't think, to the public. The ethical thing for the candidates is reporting. Are candidates malicious? Do they run dirty, nasty campaigns? Yes. This is a blood sport. And it's not for the thin-skinned. I mean, I went through it. There's nothing you can do to prevent them from doing stuff to you. You can get seek action to try to sue them, but they're not public officials. They're not. I don't care how you interpret it. I don't care what you do. I don't care what judge you send it to. They are never going to be public officials unless they're recipients of public funds.
Okay, members, I want to recognize our general counsel.
One last thing that I think is important to understand is that when complaints are filed, they're not only, the complaints aren't limited to being filed against public officers, public employees, and candidates. There's another class of people that also get complaints filed against them that I would recommend also don't have recourse here. Lobbyists, lobbying firms under, executive branch lobbyists and lobbyist firms under section 112.3215, they're also not public officers. So that they wouldn't be able to avail themselves of this either. So there are classes of people that the legislature knew how to include in a provision like this and didn't. My advice to you would be, if you want to pursue this line, your legislative recommendations would be a great place to go with this.
Okay. Mr. Chairman? Sir, you recognize.
For counsel, am I correct that if we say no to his arguments, there is no appellate recourse from that?
No, I mean, I expect that there will be an appeal of our final order in this matter.
So they could accomplish the same thing Commissioner Meigs is talking about through another vehicle.
Yeah. Yes.
I just have trouble, well, it's yet another example of inconsistencies. I have trouble substituting my judgment with whatever may have been going on in the mind of the legislature when they.
That's presumptive.
Very, very, when they enacted all these various provisions. We all know that they don't necessarily know the ramifications of the interactions of everything they do from session to session to session.
Yeah.
I guess what I'm saying is I can't vote to send this on to DOA in the face of a statutory reaction, especially if there is some remedy for them anyhow.
Okay. Sir, you're recognized.
Commissioner Simone, I have seen cases where the legislature says shall,
Yes,
and a court says what they meant was may.
absolutely.
We could have a case coming out of this if it goes to DOA where the legislature said public officers are, candidates are not public officers. And that's not what they meant, just like they say shall sometimes mean may. And we would have, then we wouldn't be talking about what we're talking about now. We would have case law that says a dadgum candidate for the purposes of ethics violations is a public officer and employee.
But don't we
We'd
get
have
to,
the clarity.
don't we get to the same position from what council just said? If we say no to them, and I'm very sympathetic to everything else you've said. If we say no to them from what council is saying, they can appeal us.
It's appealable. The final order is appealable.
Well, let Commissioner Meg finish, and then I'll recognize you.
And then I'm gonna stop. If we do what I have suggested, that puts the burden on the complainant, from what I'm hearing. And that's where it ought to be. Not on
Commissioner
us.
Meigs is correct, and, you know, selfishly, it's less work for us if it goes to DOA, but it's,
If you're a public employee,
I am certainly a resource to be deployed by you. You know, I'm shooting straight here, you know, I feel like my advice holds up. You know, how you want to dispose of the matter is certainly in your purview.
Commissioner Wallman.
Thank you, Mr. Chair. You know, it's interesting because in this case, because if you flip this and it wasn't Ms. Cervera, and it was the other one who was actually the judge who was in office and is the public officer, she could come at this stage if they had filed the complaint, and she'd be entitled to recover attorney's fees and costs in the same matter. But yet, because they're a candidate, you're saying she can't recover for the same issues. There's that inconsistency. And logically, his argument makes sense. When I say his, Mr. Cervera's argument makes sense. But, of course, we're not here to determine that. We're determining what the law is. I think the most appropriate, and I reiterate what I said before, is the way Commissioner Meigs wants to take it. Let the courts determine it. As it relates to what Commissioner Newton said, I don't think you can just make that black-white argument that, you know, it says public officer, I mean, that's what it means. There are no public funds here. Either way, so when you talked about public funds, there's nothing. This was their funds, the other candidates' funds, the campaigns. No public funds were at issue here. So it only makes sense that what we're talking about is try to stop people from filing frivolous complaints, malicious complaints, complaints that are an abuse of discretion, here. And that's essentially, factually, it looks that way. I don't know enough, I mean, but clearly what he had said, if you do look at the documents, he does allege in the amended complaint, said co-signed. There is no signature, and you can't co-sign something without a signature. So for that reason, I would like to make the motion.
Okay.
Can I, before you do that, Commissioner Wellman, because I am torn, if you don't mind.
Go ahead, no,
Is that
not at all.
appropriate?
No, not- go
Because
ahead.
I'm torn between the suggestion of the DOA recommendation, which I kind of feel like our general counsel does. I like the idea of being able to push it even for our own benefit, not just our staff's. But I will also say, if we hadn't had such a well-prepared and impassioned argument from counsel, this would have been one of those cases like the water in a condo building. It finds the easiest way to run downhill. And we've just looked at the paper here. I think that the argument is very well summarized in paragraph 3 of the recommended order. And it is a few very simple sentences. She was not a public officer or employee when the complaint was filed. Thus, the provision for the recovery of attorney's fees in section 112.317 is not applicable. It's that simple. And so, although I would like to defer to the fact finders that have time and have the ability to dig any deeper, I think we're making it more complicated by deferring to them, and that the law is clear and simple, although perhaps not as we would have it as fair to a person who's been victimized by the campaign process. But that is one of the risks all take when they engage in what was referred to earlier as a blood sport. So I don't think that council's allowed to respond as much as you're about to jump out of your skin to do so. So at that point, I'd go back to Commissioner Waldman.
Well, thank you. I'd say he probably can respond because we're not even in, there's no motion on the floor.
That's up to the chair. I
at
just
this
didn't
point,
want to.
and I have no objection to it. I just see the inconsistency in this. It doesn't make sense to me. He has pointed out to another section in the same statute which defines public officer as a candidate. Now, it does say, as what Steve had told us, it says in this section. That being said, courts in many instances, and you know, interpret that to go beyond just that section, because if it's not defined somewhere else, we've got to look to where it is defined. And that's just the legal basis, the nature of it. I agree with you, Commissioner Akers, as we talked initially, and that was why the first question I asked to Steve was of subject matter jurisdiction. And I was waiting to hear an argument that said, well, maybe we do have subject matter jurisdiction. And, you know, that's it. I mean, basically if I look at it in terms of subject matter jurisdiction, all we can do is just dismiss this because we have no jurisdiction.
Okay. Sir?
Okay, thank you. Well, for clarity, I'll say again, candidates are not recipients of public funds. That's what I was talking about. I wasn't talking about money in this turf war or whatever happened in this campaign. Candidates that I know of are not recipients of public funds. But the individuals who are responsible to the public. They have a trust bestowed upon them, and they receive public tax dollars, what they do for the public. Now, as to the statute, the beautiful thing about legislation is we got this thing called amendments. And I recommend that we do that. We have the legislature on the council's order, add a amendment to define the definition of a public officer. You can change that if you want to. I think that's great. However, I don't, and I won't participate in kick the can. What we have before us is clear, crystal clear. There's no public officers here, there's no public money being spent on the individuals that they're looking to seek remedy from. Was it wrong? Yes, but you can't cloud the issue. The issue here is a recommendation about accepting fees, and the argument is that because this individual is not a public officer, that won't happen. So I would move to accept the recommendation from our legal counsel.
Second? Well, before you second, I think I have one more question.
Well, not a question, but it's a
Or
response
comments.
to what the Commissioner just said, which is just the inaccuracy. I just want to make it clear. Candidates do and are eligible to receive public funds in the state of Florida, and that happens quite frequently in elections. So whether it happened in this case or not, I don't know, but in response to what your statement was, that's just not true.
Mr. Chairman, just a quick question,
Yes, sir.
clarification.
Yeah.
I believe that all the members of this commission are public officers, counsel. And I don't believe that any of us receive compensation for serving on this commission. That's certainly not financial remuneration. So is it not the case that a public officer is not defined by whether or not you receive public funds, counsel?
And part of the issue here is that there isn't a definition right now at all for the provision that we're interpreting. But certainly, what I'm recommending to you is that, and you know this from your own experience, we regulate public officers, and not all of them are paid. Plenty of them are volunteers. There's somebody who serves on the Parks and Rec Board, they don't get paid for that. You do not receive compensation for the work, the tireless work that you do here for this commission. So they don't, no, that's correct. The receipt of compensation is, I don't think anybody believes that the receipt of compensation or public funds to a person makes them a public officer.
Okay. All right. So I am going to weigh in a little bit on this one. And I think it's important, hearing both Commissioner Meggs and Commissioner Wallman, that it should go on to DOA. I think having them have the opportunity, I think, is the right thing to do. So with that said, is there a motion? Was it seconded?
I'll second it.
What was
Okay.
that motion?
So can you repeat the motion, please?
The motion is to receive the council's recommendation and not, let me get this right, I don't want to say it. Accept the legal's recommendation that's put before us. That was the motion.
Okay, so you're to dismiss the petition, and it was properly seconded. All right, so we're going to do a roll call.
Mr. Chairman,
Sir.
is it in order for discussion on that motion?
Oh, sure, yeah.
Mr. Chairman, I'm very respectful of attorneys who serve in this commission. I'm not one.
Neither am I.
But the reason why I can't vote for the motion offered by my respected colleague is because it's based upon an argument which I believe General Counsel has indicated is not entirely accurate. And that is the definition of a public officer as being somebody who receives public funds. I don't believe that's true. I believe it would be improper for us to take action that would leave that on the public record. And so consequently, while I'm very respectful of his ability to make a motion and his sincerity in making the motion, I believe the motion is ill advised for that reason. And so consequently, I will have to vote against the motion and see if there's another matter that we can, another way we can resolve the matter.
To be clear, his motion was to adopt the draft order.
Meaning?
Yeah, exactly, counsel, but his argument, which is certainly part of the public record, was an argument which I believe most respectfully is an argument that's not borne out in law.
Okay. Commissioner Akers, you recognize.
Thank you. And Commissioner Gates, just so I'm on the record, that's absolutely not the reason that I would espouse as my basis for wanting to support the motion. I definitely believe that public officers can serve and not be compensated. I think that the question goes more to what are the facts of this case and whether this candidate was a public officer.
Mr. Chairman, I feel exactly the same way as Commissioner Akers.
Okay. Okay. Commissioner.
Thank you. I don't know how clear I can be. Everybody sitting up here is sitting here at the expense of the taxpayer. Those hotel rooms we slept in last night, I didn't pay for it. Taxpayer paid for it. Unless the Ethics Commission has a pot of money that they get from somewhere else. But I think they're funded by the state, and the state receives those funds from taxpayers. So all I was getting at was, when you talk about public official, that is not a candidate. We have millions of candidates. And like I said, the only one I know right now that's receiving public funds or compensation of any way is the gentleman that's running for president, and he's also the governor. Okay. So I want to be clear. It's not the argument of just anyone that receives public funds. It's a public, you don't, not indirectly, but we're not paying. We don't come up here and pay here to be here and not be, have things provided for us. And those things are provided for us through means of the public and the taxpayer. And I believe that to be true, so I want that, and you can quote me, correct me if I'm wrong, legal, but I think that, that the taxpayer and the things that provided for this commission is provided by them. Because, I mean, they're using an argument that we don't receive any public resources or public money.
I think to clarify for your benefit and for Commissioner Gates's benefit, the draft order, the text of the draft order doesn't include that reasoning. It is exactly what Kathy identified it to be when she made her presentation at the very start. You've reviewed that. So it doesn't include anything about the taxpayer thing. It doesn't attempt to make a definition of public officer beyond, it doesn't make an argument about what a public officer is or isn't. It says that she isn't one based on our common understanding of what that word means, not applying any particular definition, specific definition from the code. It doesn't make a reference to the public funds argument that you're making. At the end, after the vote here, if you adopt this, the final order will speak for itself, and the text of it does not include that argument.
So,
If I may.
wait, I think, Commissioner, I think there was some other,
Well, I was
okay.
trying to talk to legal if I could.
Yeah.
I'll wait. You can do whatever.
No, go ahead.
It was, not the argument of public funds and we getting a benefit or a taxpayer paying for us. What I was trying to dispel upon was the spirit of the legislature when they came out and they declared public officer. And I was trying to differentiate between the candidate and the public officer. And I used the taxpayer resources, whatever they may be, as the means to do that. That's where I was going with that. But as was stated, we have two remedies. They can appeal it, and we can also have the recommendation to our legislative process from us to the legislature to amend it, to give us a finite definition. So this is not the end, but that's the reason I support the order that's before us. That's my rationale. It's not about public funds. It was just, everybody's trying to diffuse apart that the interpretation of what the legislation was. But I would never try to legislate from this bench or any bench. I leave that to the lawmakers.
Thank you, Commissioner. All right, so we're going to go ahead and call a roll call vote.
Yes.
Yes.
No.
No.
Yes.
No. Yes.
Yes.
No.
Yeah. All right.
As divided as you can get.
No, it was 4. 5-4. All right.
Commissioners, thank you for the spirited debate.
Moving on to Section 8, items concerning commission expense. We would like to recognize our Executive Director.
All right, thank you, Mr. Chair. Members, this, if you've been with us at least for the last year, each year, I bring to you a request for the authority to make certain expenditures. My expenditure authority is limited to $10,000. And so I need a commission's vote to approve expenditures noted in the memo in your materials. Those were items that were included in our budget. It includes one of the Westlaw contracts, our office lease for space, as well as the Attorney General's contract. At this point, there are a couple of different AG contracts in operation. One is related to the federal litigation, which is now something that we are having to pay for out of our budget because it is no longer under the risk category because there are no longer damages. The other contract is the one that goes for our advocates and their staff. That number came in to me yesterday as $442,561. That amount includes the advocates, their space, their paralegal assistant, and that does encompass the, assuming that it is signed, the 5% across the board increase. What that amount would not include would be if the advocates do choose to have another paralegal position or increase the position that they're currently, that they currently have in place. And so I would like your authority to move forward with that in discussion with the advocates in terms of what their additional needs might be to handle the caseload
Mr.
that they
Chairman.
have.
Sir.
Mr. Chairman, I move that the commission extend the spending authority as requested by the executive director in our May 24th memo.
Second.
All right, I see that Commissioner Newton has a question.
Yes. Is this a, and this is what I take it, is this a budget adjustment or a spending authorization? Is it more, adding more or less, or what are we doing?
You recognize.
Commissioner, it is a spending authorization. None of this would exceed what was proposed in the budget.
I'm glad to see we're getting a new station wagon.
Okay, Commissioner Ankers and then Commissioner Moore.
Speaking of the station wagon, is it typical for agencies of this size to have a vehicle?
Through the chair?
Yes, ma'am.
I do not know an answer to that question. I know there are many, many state vehicles around town. I do not know if we are unique in having a vehicle for our size.
I trust that it's used for transport for training in lieu of a rental car, and that the cost analysis on renting versus purchasing is the justification for the expenditure.
Through the chair, since the time the commission moved out of the Capitol and we have meetings, the car is used for meetings transport. It can be used for investigators who are traveling out of town in lieu of going to get a rental car. Sometimes that takes them longer out of the office in this town to go get a rental car than to just, run to the next town. But yes, we will look at an analysis of that in light of the rental car cost. But currently, our station wagon is not running. And this would then be the third car that the commission has had since 1993.
Commissioner, you're recognized.
I've raised this question here, and here appears as if we're extending lease, staying in the same location. Is that correct?
That is correct.
The question I had raised at a prior meeting was issues of security. You can get into that building rather easily and go where you want to go. Has anything been done about that, or is the landlord willing to make any appropriate changes?
Through the chair, we did, in the negotiation of that new lease, get consideration from the leaseholder, the building owner, that we could put some cameras down at that elevator, and we do have the ability to lock it during business hours. So we're doing research. We won't be able to make any of those purchases until after July 1, but we do plan to put some more things in place.
Commissioner, you're recognized.
Thank you, Mr. Chair. So regarding the Garcia versus Stillman litigation, I don't recall, I don't think we've had any shade meeting or anything like that as far as this commission goes. And now that it's not covered by insurance, apparently, shouldn't we weigh in on whether or not we want to continue pursuing it or anything like that? Because this is going to come out of our budget from what I read here.
Ma'am?
Through the chair, I'm going to defer to the general counsel. I think it's a defense of a constitutional amendment, and so we are obligated to do so.
In my role as general counsel, I've been monitoring and advising the Attorney General who's been representing us in this, and letting him know what it is that we would like to do. And with that, I've been presuming along the way what it is that you would want me to do as your general counsel in directing that litigation. This is a challenge, a constitutional challenge to the constitutional amendments for 2018 that were passed by the voters. 79% of the voters wanted this particular amendment. It's now being challenged. It's a constitutional challenge because there's no damages. Risk management is no longer paying the bills. It had started off with money damages in it, as you'll recall, and so risk management was paying the bills to a certain point, and then in early April, after an order came out dismissing the money damages, it no longer was a risk case. We picked up the bills since then. Because the voters wanted this, and it's a constitutional challenge, and it's relevant to the authority that we were given by the voters to pursue this, to enforce this particular provision, I've been operating under the presumption that you would want to protect the authority and protect the will of the voters in pursuing the litigation, so I've been operating under that assumption. If you feel differently about pursuing that or paying those bills, a shade meeting would be appropriate.
So just to follow up, so would it be inappropriate then at this point for me to continue on to discuss this in light of this? But, because I actually now go to where I'm with Commissioner Newton on the public fisc. We're actually spending the public's money now in a lawsuit that potentially will harm the budget of the Commission on Ethics. And because we know attorney's fees can quickly overtake litigation. And I'm just saying that it sounds like it's more something we should discuss in a shade meeting as to where we go. If we have a responsibility for something, that's one thing. But we also ought to not have to be paying for this litigation through the budget of the Commission on Ethics.
To be perfectly clear, we are paying a third of the litigation costs.
Still
because
paying.
There are two other, yeah, we are still paying, of course, but to be clear as you discuss this, the office of,
DFS.
Jimmy Petronis's offices and the Office of the Attorney General are the other two defendants in the matter. So the legal bills have been split three ways. So we do have a third of it.
Mr. Chairman?
Sir.
Mr. Chairman, are we in proper, to get to Representative Waldman's point, are we in a proper forum to discuss this matter, or should we be in a different forum? Because I certainly would like to be debating the matter as the author of this constitutional amendment, but I don't want to do so in an improper forum.
Absolutely. So can you share with us, what is the procedure of moving forward into a shade?
We won't be able to do it today.
Okay.
One of the very first thing that needs to happen, and I don't have this up in front of me, but the statute that allows us to go into a shade meeting, the first thing that needs to happen is that the attorney who's representing us needs to present to you, needs to say in the public meeting that he or she requires advice or guidance on a particular matter, and that would either be about litigation expenses or about settlement authority. Certainly, you have presented some questions about litigation expenses. Our attorney would be able, the attorneys who are representing us would be able to provide you information about that. You would have questions. They have questions about whether or not you're willing to pursue this now based on this expression of concern about the costs. So those are things that I think could come up in a shade meeting, but the attorney would need to be here.
Okay, one more procedural question. Knowing that our next meeting is not till 6 weeks from now, would that be something that we would probably have to reconvene a shade meeting prior to that, or is timing?
I don't get to summon you all here, but
Right.
if you want to meet on that more urgently, then a new meeting would need to be scheduled.
Okay, and 7-day notice, correct?
Right.
Okay. Yes, ma'am.
We could do that via Zoom.
By the time we meet again, the trial will have occurred. Is that accurate?
So if there is a scheduling order in the case, there has been a request for an extensions by the plaintiffs for the filing a motion for summary judgment. I believe that we filed ours last Friday. I'm not sure if they have filed theirs or not, but because of the extension, there is an assumption that it will affect the scheduling order and push the trial if the motions don't resolve the matter and the matter ends up going to trial. I believe it was already scheduled for mid-August is when the trial would have been. Motions for summary judgment are already filed, at least on our behalf. And so things are moving quickly. And on top of that, on the disposition of the merits, we are also incurring fees on defending the appeal of the preliminary injunction. As you'll recall from an email that was sent to you by Carrie Stillman, we prevailed on a motion to stay the preliminary injunction, so we are now able to enforce the in-office restrictions. So there's a stay pending the full hearing of the appeal by the 11th Circuit. It's It's unclear whether or not the 11th Circuit matter will finish before the merits at the district court, or if the district court will trail the findings by the 11th Circuit. It's a little clear who's going to win the race, so to speak. But those two things are operating in parallel right now, and we are incurring fees on hold.
Now, the shade meeting can be done virtually, correct? Or does that require to be in person?
You don't need to be present.
Okay. It just needs to be publicly noted that there will be a shade meeting virtually.
Yes, the meeting would start in a public session, so only for the attorney to say, I require some guidance on litigation expenses, and then you would go into shade at that point.
Okay. Members, any questions?
I do.
Okay.
Maybe naive or just ignorance on my part, but is it common practice for the Attorney General of Florida in representing any board, commission, or agency of the state of Florida to bill those agencies for that service?
Very common. We sign a letter of authorization allowing them to represent us. They have labor costs, of course, and those labor costs can be extensive as far as representing the agencies, and then the agencies do that.
Why would that not be part of their responsibility absent that?
I'm not clear on why it isn't, but for whatever reason, that's not the way it works.
Yes, sir.
So, thank you, Mr. Chair. Just to be clear, I'm not expressing an opinion one way or the other, whether I think we should settle or do anything. I'm just bringing it up for discussion purposes. But I do want to get clarity. You asked if we could have a virtual meeting, I thought is what you said, shade meeting. And I don't know, we could have a virtual shade meeting, so none of us have to come up here. But you have to have a public meeting first where it has to be requested.
Through the chair, it would commence in public session, and then you would immediately, not immediately, but you would shift to executive shade session in the virtual, during that same virtual meeting.
So we can have that virtual public meeting first?
Yes, and you did that during the pandemic ones.
We did?
Yeah.
We did.
Yeah.
Oh, we did it, no, we did it with a budget or something, I thought.
We also did it within I think at least one meeting during the pandemic before we started.
Okay.
Commissioner, you're
Thank
recognized.
Oh, go ahead, if you're following up. I just want to express, while process starts to give momentum to an idea, I personally don't feel the need for a shade meeting, and very comfortable with moving the same way that we are now. And I'm comfortable also expressing that in a public forum, that I think that the fees expended compared to the scope of the issue is warranted and justified. And my guess is that a lot of fees that have been expended to date that we're actually moving toward the end, one way or the other. And at this point, we should continue on the path we're on. And I'm just saying that so that we don't even expend the additional fees to have the Attorney General come prepare for this presentation, participate in a meeting, and then go to the next step. So I'm comfortable staying where we are and getting the report at the next meeting, or going to trial.
Okay. Commissioner, you're recognized.
In addition to that, when the budget was set, dollar amounts were set for each department for things like this, if I'm not mistaken. That's why I asked, was it a budget increase or was it a spending authorization? So it's already budgeted, am I correct, 40,000, whatever?
Madam Director, you're recognized.
Through the chair. Yes, when we met, I did have money based on my understanding of costs placed in our proposed budget. You might recall at the last meeting I mentioned that our appropriation came in under what we requested due to some differences with the Division of Administrative Hearings amount that came in much higher than what we anticipated. But my understanding from conversations with downtown that we would have some flexibility due to the amount that we have currently in carry forward, where they felt like we could meet all of the budget requirements that we had and the things that the commission wanted to do with the monies available to us.
I concur, Commissioner Anchor, to that fact. Not only that, we're only on the hook for a third. If it was all of us by itself, I'd be worried about it going through the stratosphere.
Thank you,
But even at that event, you would come back if it went beyond the budget.
Yes, sir.
Thank you, sir. Commissioner, you're
Thank you,
recognized.
Mr. Chair. Just to be clear, though, as I said, I'm not expressing an opinion one way or the other. What I also believe is we're a party to a litigation. It's pretty wise, I think, to know what exactly is going on in that litigation and to hear it from our attorneys to tell us what's going on. So it's not a matter of whether I support going forward or not. I think it's important that we are able to freely discuss the litigation and what we think should be done.
Okay.
Mr. Chairman. Yes, sir. Mr. Chairman, there's a motion on the floor.
Unless it's not appropriate.
Having to do with spending authorization for currently budgeted funds. And I would like to respectfully request that we take up that motion, and I would respectfully request as well that the chair take under advisement the requests from several members to conduct a shade meeting if necessary.
Absolutely.
I'll second that motion.
All right, so it's probably moved in second. Any discussion on the motion?
Just to be clear on the last thing that Commissioner Waldman said, an update on how the litigation is going would not meet the requirements for a shade meeting. That would have to happen in public session. You know, we've taken the posture of trying to avoid a public session discussion of this matter because we don't want to discuss strategy. And I, you know, hand in hand with any discussion about how it's going is you might be tempted to start asking questions about strategy, and those would be not shielded by, those would be appropriate for the public session, not appropriate for a shade meeting. So we.
The strategy, you're
Right,
saying strategy would be appropriate for a public meeting?
Unfortunately, the way, and there is plenty of case, I had to review this when we got started here because I thought a shade meeting might be appropriate to discuss how we were going. And what I've learned in my review of it is that the two things that you are allowed to discuss here are the subject matter of the meeting may be confined to, the subject matter of the shade meeting may be confined to settlement negotiations or strategy sessions related to litigation expenditures. Those are the two things that you would be able to discuss in the shade. Everything else about the litigation would need to be discussed publicly.
Mr. Chairman, I think that's plenty of justification for a shade meeting if you as chair decide to call it. And I'm sure council will keep us from wandering off the reservation if we have a shade meeting.
Absolutely. All right, so it's been properly moved in second. We're in the discussion posture. Is there any other discussion? All right. All in favor, say aye.
Aye.
Any opposed? Seeing none. With that said, also, just for the record, I'm going to ask that the executive director find some time with members to conduct a shade meeting. All right, moving on to the next thing is the executive director report.
Thank you, Mr. Chair. I want to introduce Amelia Naomi. She's here with us today in the back of the room there. She just completed her 2L year at the Florida State University College of Law, and she is our summer intern. She started in May. She's been involved in the drafting and review of legal documents related to complaints, financial disclosure, as well as litigation, and has already proven to be an asset to our legal team. So we're glad that she's here with us. She's also going to be splitting some of her time to serve as a part-time temporary OPS employee during our peak disclosure weeks, which are soon upon us. So we'll benefit from her help there. Also, not at this meeting, but watching the meeting and holding things down back at Ethics Headquarters is a new full-time member of our administrative support team. Brandon Garner also joined us in May. We've been busy, and he has been a great addition to our staff and has shown himself to be a self-starter, and so we're very happy to have him on board. We also have hired 2 temporary part-time clerks for summer OPS work for disclosure season. Joining us through the early part of July are Janice Suarez and Jeremy Pennington. So I hope you'll join me in welcoming them to our wonderful team of ethics professionals. With the chair's permission, I'd like to go ahead with the legislative
Yes,
report and
please do.
e-filing update. Legislative report is in the memo in your materials. Since mail-out, all of those bills that had not yet been signed were signed into law. I did note with the early legislative session, the January 2024 legislative session will come faster than we know it. So I'd like to invite you to contact me with any potential legislative ideas that you have so that we can put that on an agenda possibly as early as March. And during your discussion earlier in those cases, I had already noted some things down for us to talk about. So that concludes my legislative report, unless there are any questions related to
As
that.
early as March?
Did I say March?
You did.
As early as July.
Thank you.
Excuse me. Thank you.
Mr.
Minute
Chairman,
time.
just a quick comment to compliment, pardon me, our executive director and our general counsel on the work they did. It has been more than 20 years since the Ethics Commission has had the ability to increase penalties for those who commit egregious acts. And there have been many, many attempts to strengthen the Ethics Commission's hand, and to borrow a phrase that's often used in the press, to give this commission more teeth. Those efforts have all failed. This time, it succeeded. And it succeeded because we have a great executive director and a great general counsel who met with staff, legislative staff, who got them on board early, who met with sponsors, got them on board, and made sure that the sponsors of these bills work their way through the process. I want to also thank members of the commission who may have been in contact with members of the legislature to help us out in getting these matters passed. But if you look at the executive director's report as to the additional teeth that this commission has been given as to penalties, as to financial disclosures, and then also sort of a cleanup of some of the underbrush that we have with the lobbying issues. This was, in my memory, the most successful legislative session in more than a decade. And I want to just point out that the reason why that occurs is not only the good work that members of this commission have done in working with their legislative friends, but also because of our executive director and general counsel. This is, it's not the Declaration of Independence. It's not quite that important, but it is the most significant legislative achievements of this commission in more than a decade.
Thank you, sir. That was good.
Thank you. It's, they certainly whittled down the list of the commission's recommendations, and I have drafted for the chair's signature some letters that will go out to Speaker Renner and President Pasadomo, Senator Broder, and Representative Roach to thank them for their leadership and support of the commissions.
Awesome. All right.
Can I just add one? Thanks to no one in particular, but they should know who they are on the commission, that in order to get that additional enforcement authority, you had to use the enforcement authority that we were already granted. And we had to begin to do that and do that more effectively and consistently. And I think once we started to do that, then perhaps the legislature, in addition to the good work of the staff and the members, felt that we were justified in getting it. So thank you to those who helped lead us to take advantage of the law that was on the books.
We all, Mr. Chairman?
Yes, sir.
I also want to commend them on the Senate Bill 750. It has a provision that we spoke about this morning of money owed to the commission for fines and fees of individuals seeking to, candidates seeking to get into office.
Okay.
That's a good thing.
All right. Anyone else? All right, Madam Executive Director, you're back up again.
Okay. Thank you, Mr. Chair. With e-filing, the official annual notice to file for almost 40,000 financial disclosure filers in the state at the state and local level was sent out in May. The one for e-filing was sent on May 8th. And so far this year, there has been a total of 972, it's roughly 37% of the annual Form 6s electronically filed as of yesterday. That is 448 constitutional officers and 524 judges who have filed so far. We're pretty happy with that. That is on par with previous years on paper, if not a little bit ahead. We've had some help with the different associations who are stakeholders. The association groups of the constitutional officers, we reached out to them. They've been helping us to get the word out. So we're expecting 2,623 forms by July 3rd. July 3rd is the deadline this year because July 1 falls on a Saturday, and that just goes for Form 6s. So we have 23 more days until that deadline, and we're looking for 1,651 more Form 6 filers to get their form in electronically. Also, slowly but surely, the paper Form 1s are also arriving in our office, and things are going to get pretty busy there in the coming weeks. Busy is an understatement from the work that will be getting done. I don't want to jinx things, but it has been relatively smooth on the e-filing front. It's not been perfect, but I'll take it over last year. The tech team has been very responsive in addressing any unexpected errors or technical issues that we've encountered up to this point. Kim, Lynn, and I provided a live webinar for filers on Wednesday of this week where we provided an overview of the system and took questions from the attendees or the filers at the webinar. We had more than 120 registered to take that webinar class, and we've been working to get that recording posted on our website so it is available to anyone who might have wanted to be there because it was riveting. But now they can watch it from the comfort of their offices. So if it's not already on the website, it will be there shortly. As I mentioned at the last meeting, there's a few major technical issues that we are working to address during the filing season in anticipation of user acceptance testing for Form 1s that launch in January. The public search is being rewritten to make sure that it's pulling all the 6Fs and the 6Xs as well as the 6s it's already pulling. It's also dealing with the how the system selects the position that is the primary contact position for a person's agency. As you know, many of you might serve on other boards. The system has to deal with that, and it's quite complex. Also, the way the system deals with duplicate filers, when we have people with the same names, there's some work that has to be done there. And of course, not last but not least, the Form 1 and the Form 2 have to be ready to go. We've set a deadline for September 1 for user acceptance testing. We don't have much of a buffer because of all the work that had to be done to make things happen for the uploaded files as required in 774, as well as the tax returns. So we are working feverishly to get things done so we have time to test the functionality of the system for the Form 1 and Form 2, handle any bugs or glitches, and prepare training materials, augment staff, and train staff for that January 1 launch. The IT team has had some staffing issues. As I've mentioned, the architect position is still vacant. Notwithstanding that, they've been stellar. I think also Director of OLITS will be leaving soon for another position, but she has been incredibly supportive and helpful with this project and has definitely made a positive impact on it. Our team lead for the project still remains in place, as well as numerous members of that team who we truly appreciate getting us to this point. We're in constant communication with them. And of course, the House and Senate IT have indicated that they will commit resources from their offices to assist us as we get rolling to plug any gaps that we might have. So with that, I have nothing else unless there are questions related to e-filing.
Members, any questions? Seeing none, Commissioner Moore moves that we adjourn.